I'm Charlotte Mitchell, Chair of the Utilities Commission, and with me this afternoon are Commissioners Duffley, Hughes, McKissick, Kimmerite, Brawley, and Tucker. I now call for hearing docket number E-22 sub 694 in the matter of application of Virginia Electric and Power Company doing business as Dominion Energy North Carolina for adjustment of rates and charges applicable to electric service in North Carolina. Before we proceed further, and as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflict of interest. Inquire at this time as to whether any member of the Commission has a known conflict with respect to matters coming before us in this docket. The record will reflect that no conflicts have been identified, so we will proceed. On February 28th, 2024, Dominion Energy North Carolina, or DENC, pursuant to Rule R117 Sub A of the Rules of Practice and Procedure of the Commission, filed its notice of intent to file a general rate case application. Thereafter, on March 28, 2024, DENC filed its general rate case application requesting authority to adjust and increase its rates for retail electric service in North Carolina effective May 1, 2024. Accompanying the application were the direct testimony and exhibits of DENC's witnesses. On April 15, 2024, the Commission issued an order establishing general rate case and suspending rates. Then on June 13th, 2024, the Commission issued an order scheduling hearings, establishing procedural and filing requirements, and requiring public notice. This order scheduled public witness hearings to be held in Manteo, Halifax, and Williamston, as well as one to be held remotely by way of WebEx for the purpose of receiving testimony from DENC's customers regarding the proposed rate increase. This order also scheduled an expert witness hearing to begin today at this time and at this place. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute, Section 62-15 Sub D. The Attorney General's Office gave notice of intervention in this docket on behalf of the using and consuming public pursuant to North Carolina General Statute, Section 62-20, and on behalf of the state and its citizens pursuant to North Carolina General Statute, Section 114-2 Sub 8. In addition, the following parties petitioned and were allowed to intervene in this proceeding by order of the Commission: the Carolina Utility Customer Association Incorporated, the Carolina Industrial Group for Fair Utility Rates 1, or SIGFR, and Nucor Steel Hertford. On August 5th, 2024, DENC filed supplemental testimony and exhibits of certain of its witnesses. On August 16th, 2024, DENC filed the second supplemental testimony and exhibits of certain of its witnesses. On August 30th, 2024, the public staff, SIGFR, and Nucor filed the direct testimony and exhibits of their witnesses. On September 10th, 2024, the public staff filed the supplemental testimony of certain of its witnesses. On September 17th, 2024, DENC filed the rebuttal testimony of certain of its witnesses. On September 20th, 2024, DENC filed affidavits of publication as required by the scheduling order. On October 1st, 2024, DENC filed the agreement and stipulation of settlement by and between DENC, the public staff, and SIGFR, which was later corrected by a filing made on October 2nd. On October 2nd, 2024, the public staff filed testimony of certain of its witnesses in support of the settlement agreement, and DENC filed testimony of certain of its witnesses in support of the settlement agreement. All right, that brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record, and we will start with the applicant.
Good afternoon, Chair Mitchell, members of the Commission. I'm Mary Lynn Brigg with the law firm of McGuire Woods, appearing on behalf of the applicant, Virginia Electric and Power Company, doing business as Dominion Energy North Carolina. Also here is co-counsel are Ms. Andrea Kells and Mr. Nick D'Antonio.
Good afternoon, Ms. Grigg, Ms. Kells, and Mr. D'Antonio.
Good afternoon, Commissioners. My name is Ann Keyworth. I'm with the public staff. With me today are Will Freeman, Nadia Lohr, Zeke Creech, Tom Felling, and Jennifer Herod, and we represent the using and consuming public.
All right. Good afternoon, Ms. Keyworth and the rest of the Public Staff Legal Division. All right, Mr. Trathan.
Yes, good afternoon, Chair Mitchell, Commissioners. I'm Marcus Trathan with the law firm of Brooks Pierce, appearing today on behalf of CUCA.
Good afternoon, Mr. Trathan.
Good afternoon, Commissioners. Robert Josie with the law firm Nelson Mullins on behalf of Nucor Steel Hertford.
Good afternoon, Mr. Josie.
Good afternoon, Commissioners. My name is Ashley Stokeham with Bailey and Dixon, appearing on behalf of SIGFR 1.
Good afternoon, Ms. Stokeham.
Good afternoon, Commissioners. I'm Derek Mertz,
here on behalf of the Attorney General's office.
Good afternoon, Mr. Mertz. All right, preliminary matters before we begin.
Yes, Chair Mitchell, the company would like to move several items into the record if it pleases the commission or into evidence.
All right, please proceed.
First, the company moves that DE&C's application is filed on March 28th, 2024, including appendices 1 and 2 and exhibits 1 through 10 be admitted into evidence. The application did include confidential information and was also accompanied by the Form E1 documents with items 10 through 12 and 20 through 32 being confidential, and as supplemented on April 1st, 2024, April 17th, 2024, April 18th, 2024, August 5th, 2024, August 6th, 2024, August 14th, 2024, August 16th, 2024, September 18th, 2024, October 2nd, 2024, and October 4th, 2024.
All right, having heard no objection to the motion, I will allow it.
Next, the company moves that the stipulation, agreement and stipulation of settlement between DE&C, the public staff, and SIGFR is filed on October 1st, 2024, consisting of 16 pages, be admitted into evidence.
All right, having heard no objection to that motion, I will allow it.
And then the company also moves that the corrected agreement stipulation of settlement consisting of 16 pages and 1 exhibit as filed on October 2nd, 2024, and the amended agreement and stipulation of settlement as filed on October 4th, 2024 also be admitted.
All right, having heard no objection, I'll allow that motion.
Would you like me to go through the testimony at this time?
Let's go ahead and do that, Ms. Kels.
All right, the company also moves that a number of testimony of witnesses and their exhibits that I will list be admitted into evidence at this time, as these witnesses have been excused from appearing at the hearing. First, the direct testimony of Edward Bain, filed on March 28th, 2024, consisting of 23 pages and 1 appendix. The direct testimony of Jerry Brooks, filed on March 28, 2024, consisting of 8 pages and 1 appendix. The direct testimony of Richard Davis, filed on March 28, 2024, consisting of 14 pages, 1 appendix, and 1 exhibit. The supplemental testimony of Mr. Davis, filed on August 14, 2024, consisting of 2 pages and 1 exhibit. The rebuttal testimony of Richard Davis, filed on September 17th, 2024, consisting of 10 pages and 2 exhibits, as corrected on October 4th, 2024. And finally, for Mr. Davis, the settlement testimony filed on October 2nd, 2024, consisting of 3 pages. Next, the direct testimony of Kevin Fields, filed on March 28th, 2024, consisting of 13 pages and 1 appendix. And Mr. Fields' rebuttal, filed on September 17th, 2024, consisting of 18 pages and 3 exhibits. Next, the rebuttal testimony of James Gabbert, filed on September 17th, 2024, consisting of 7 pages, 1 appendix, and 2 exhibits. Then the direct testimony of C. Allen Givens, filed on March 28th, 2024, consisting of 38 pages, 1 appendix, and 1 exhibit. Mr. Givens' first supplemental testimony, filed on August 5th, 2024, consisting of 13 pages and 1 exhibit. Mr. Givens' second supplemental testimony, filed on August 16th, 2024, consisting of 5 pages and 1 exhibit. Mr. Givens' rebuttal testimony, filed on September 17th, 2024, consisting of 36 pages and 1 exhibit. And Mr. Givens' settlement testimony, filed on October 2nd, 2024, consisting of 6 pages and 1 exhibit. Next, the supplemental testimony of Rachel Hagerman filed on August 5th, 2024, consisting of 5 pages, 1 appendix, and 1 exhibit. Then the direct testimony of Christopher Hewitt filed on March 28th, 2024, consisting of 20 pages, 1 appendix, and 1 exhibit. Mr. Hewitt's first supplemental testimony filed on August 5th, 2024, consisting of 5 pages and 1 exhibit. Mr. Hewitt's second supplemental testimony filed on August 16th, 2024, consisting of 9 pages and 1 exhibit, as corrected on October 4th, 2024. The rebuttal testimony of Mr. Hewitt filed on September 17th, 2024, consisting of 8 pages and 1 exhibit. Next, the direct testimony of Jeffrey Matson filed on March 28th, 2024, consisting of 6 pages, 1 appendix, and 1 exhibit, and the supplemental testimony of Mr. Matson filed on August 14th, 2024, consisting of 2 pages and 1 exhibit. The direct testimony of Robert Miller filed on March 28th, 2024, consisting of 39 pages, 1 appendix, and 1 exhibit. The first supplemental testimony of Mr. Miller filed on August 5th, 2024, consisting of 11 pages and 1 exhibit. The second supplemental testimony of Mr. Miller filed on August 16th, 2024, consisting of 6 pages and 1 exhibit. Mr. Miller's rebuttal filed on September 17th, 2024, consisting of 47 pages, with the exhibit filed on September 18th, 2024 to that rebuttal testimony. And Mr. Miller's settlement testimony filed on October 2nd, 2024, consisting of 7 pages and 1 exhibit. Next, the confidential direct testimony of Jeffrey Mishakowski filed on March 28th, 2024, consisting of, just a second. "24 pages and 1 appendix." And Mr. Mishakowski's rebuttal testimony filed on September 17th, 2024, consisting of 29 pages and 2 exhibits. The confidential rebuttal testimony of Virginia Moncall filed on September 17th, 2024, consisting of 9 pages, 1 appendix, and 1 exhibit, as corrected on October 4th, 2024. The direct testimony of Jennifer Nelson filed on March 28, 2024, consisting of 75 pages and 9 exhibits. And Ms. Nelson's settlement testimony filed on October 2nd, 2024, consisting of 10 pages and 1 exhibit. And the rebuttal testimony of John Spanos filed on September 17th, 2024, consisting of 13 pages and 1 appendix. The company moves that all of these testimonies and associated exhibits be entered into the evidence of this proceeding.
All right, I've heard no objection to the motion, so the testimonies identified by counsel will be copied into the record as if delivered orally from the stand. Portions of those testimonies are confidential, so we ask that you work with the court reporter to ensure that those portions are appropriately redacted in the transcript. The exhibits to the testimony will be marked for identification as they were when they were pre-filed, and those exhibits will be admitted into the record in this proceeding.
Thank you.
All right, with that, I believe you're ready to call your first witness, or your panel, I'm sorry.
Yes, Chair Mitchell. The company now calls Paul McLeod and Christopher Lee to the stand.
Good afternoon, gentlemen. Go ahead and have a seat. And if you would, there should be a Bible up there. Raise your right hands, left hand on the Bible. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Ms. Gray.
Thank you. Good afternoon, gentlemen. Mr. McLeod, would you please state your name and business address for the record?
My name is Paul M. McLeod, and my business address is 120 Tredegar Street, Richmond, Virginia, 23219.
By whom are you employed and in what capacity?
I am Director of Regulatory Accounting for Virginia Electric and Power Company, which does business in North Carolina as Dominion Energy North Carolina.
Turning to you now, Mr. Lee, would you please state your name and business address for the record?
My name is Christopher J. Lee, and my business address is 120 Tredegar Street, Richmond, Virginia, 23219.
By whom are you employed and in what capacity?
I am Manager of Regulatory Accounting for Dominion Energy North Carolina.
Did you cause to be pre-filed in this docket on March 28th, 2024, 46 pages of direct testimony and one exhibit?
We did.
Did you also cause to be pre-filed in this docket on August 5th, 2024, 16 pages of supplemental direct testimony and one exhibit?
We did.
Did you also cause to be pre-filed in this docket on August 14th, 2024, 9 pages of second supplemental direct testimony and one exhibit?
We did.
And did you also cause to be pre-filed on September 17th, 2024, as corrected on October 4th, 2024, 47 pages of rebuttal testimony and one exhibit?
We did.
Did you also cause to be pre-filed on October 2nd, 2024, 5 pages of stipulation support testimony?
We did.
Do you have any corrections or changes to your testimony or exhibits?
We do not.
If I were to ask you the same questions that appear in your testimony today, would your answers be the same?
Yes, they would.
Chair Mitchell, at this time, I move the pre-filed direct, supplemental, second supplemental, rebuttal, and stipulation testimonies of Mr. McLeod and Mr. Lee be copied into the record as if given orally from the stand, and that their direct, supplemental, second supplemental, and rebuttal exhibits be marked for identification as pre-filed.
All right, having heard no objection to your motion, I will allow it. The direct first supplemental, second supplemental, rebuttal, and settlement testimonies will be copied into the record as if delivered orally from the stand. Exhibits thereto will be marked for identification as they were when they were pre-filed. One quick correction, just for purposes of the record, there are 2 appendices to the direct testimony. Just want to make sure those are included in the materials that are admitted to the record. All right, with that,
The witnesses are available for commission questions.
okay. Good afternoon, gentlemen. We appreciate your being here with us today on behalf of the Dominion team. We'll do our best to keep the questions focused on your area of expertise, but I do have one question for you that may kind of get beyond the scope of your testimony, and I'm hoping you can just do your best to give me an answer. All right, I want to start with the provision in the settlement agreement that pertains to the recovery of CCR costs going forward. So as we understand it, the company and the settling parties have agreed to the establishment of a rider that would allow the company to recover as operating expenses those costs it incurs going forward. And so first, would you confirm our understanding?
Yes, that is correct.
Okay. And have you all, at this point, have you all, meaning has the public staff and the company worked out the mechanics of that rider? Have you all decided sort of how, when, how it's going to be filed, when it will be filed? And if so, could you fill us in on those sort of housekeeping details?
Yes, we have held conversations and discussions with the public staff about the timing of the upcoming rider filing for the proposed rider filing. What we've discussed so far with the staff is that an interim rate would be proposed to begin on February 1st, 2025, representing costs incurred from July 1, 2024 through December 31 of 2024. And those would be what the initial rider rate would be based on, which would begin in February of 2025. And then afterwards, the company is proposing to file its initial rider filing in August of 2025, using similar timing to the company's fuel, DSM, and SIPS rider filings.
Okay, so, it sounds to me from based on what you've testified to, that the company and the public staff have discussed Dominion's filing the CCR cost rider contemporaneously with, on a going forward basis, kind of setting aside the provision for the interim rate, but making the filing contemporaneous with your other annual rider proceedings in August. Is that correct?
Yes, that's correct.
Okay. And have you all discussed the public staff's audit of the expenditures the company seeks to recover through the rider?
Yes, yes, we have. It is our understanding that the public staff will audit those costs in the August rider filing. However, the company will provide monthly reports to the public staff beginning in January of 2025. That report in January 2025 will have all the costs representing the period covered by those interim rates. So we'll have costs from July 1 of 2024 through December 31 of 2025. So, and we're anticipating filing those costs with the docket in this proceeding. And so parties to that docket will be able to review or to see the costs associated with that initial interim rate version of cost for the rider. But then once we get into the actual rider filing in August, that's where we anticipate those costs would be audited by staff and other parties.
Okay. So for again, not talking about the interim rate, but the going forward rate would be, we're not talking about a prospective rate like we have with the other rider proceedings. This would be a rate that reflects your actual costs incurred.
Correct.
Okay. Has the public staff and the company agreed on the interim rate that you all would propose to take effect in February of 25?
No, we have not provided the public staff with those costs to date, but we can. And it's my understanding that we would provide those costs in January of 2025. But to date, we have not provided those to staff.
Okay, understood. And have you discussed timing of the provision of those records and of that information to the public staff?
Yes.
Okay. To the extent that the public staff takes issue with any of the costs that the company incurs associated with its CCR obligations, how does the company envision the public staff's bringing that issue to the commission's attention?
I would imagine it would come to the commission's attention via the discovery and hearing and testimony filing process within the rider proceedings.
Okay, so for the rider proceeding, you all do envision having formal procedures like we do for your other riders?
Yes.
Okay. Okay. Does the company, I recognize your testimony is that you have not provided costs that you're going to seek to recover through that interim rate mechanism that you've described here. But does the company anticipate that those costs will be materially different from the sort of ballparking the 9 million initially included for recovery or proposed for recovery in this proceeding?
Yes, the initial estimates that we've prepared internally and reviewed are estimated to be between 7 and 8 million.
Okay.
In comparison to the 9 million that was included in the case.
Okay.
And that includes actual data through August of 2024 and then projections for the rest of 2024. So they are subject to change.
Okay. Okay, so you envision by the time you provide data to the public staff, it'll be you will be providing actuals to the public
Yes.
staff. Okay,
Yes.
got it. Okay, thank you. Okay, the stipulation provides that the rider shall be a rolling balance and that under and over collections are included in the calculation of rates for the next period. can you walk us through how the rolling balance will work year to year, including whether you'll seek to recover your carrying costs or financing costs?
So.
On any under recovery? Let me be clear with my sentence.
I will start with the last part of your question
Okay.
first. We do not anticipate calculating carrying cost on the, or financing cost on the over or under recovery associated with the rider filing. So I'll start with that part first. The rolling balance will be made up of the cumulative balance of spending that the company has incurred in the prior period, related to the rider filing that we're currently trying to recover. So we will take the cumulative cost and net those against the cumulative recoveries that we have received at that time. And then that will represent the net balance that will then get rolled into the subsequent rider filing.
Okay. All right. It sounds like maybe to the extent that there is an over recovery, you all haven't addressed that issue with the public staff yet.
I could add on that. So the way the rider works is we will be recovering cost in arrears. So for example, when we file in August, I think the stipulation envisions maybe we could update through September. So we're setting a rate for the following February to recover cost incurred through September of the prior year. So I think we're envisioning that this rider would always have some under recovered balance. And it likely, unless, something extraordinary happened, or perhaps maybe in the final year, there may be an over recovery, but I don't think we envision there being an over recovery.
Okay. Okay. That's helpful. Thank you. Let me see. Let me make sure I've covered the ground there. All right. Let me change topics on you all. The uncollectibles expense, there was testimony from the company and from the public staff, and then there was ultimately a settlement position reached on uncollectibles. But can you help us understand how you arrived at that agreed upon percentage? What period of time was used to derive the stipulated percentage for the uncollectibles?
So the company's position in our filing is we used an uncollectible rate based on our test period, so calendar year 2023. The public staff used, I believe, a 5-year average of information that was in our Form E-1 filing. In our rebuttal, we took issue with some of those calculations. So, there was a difference between us and public staff there in our rebuttal. And then ultimately during settlement, we agreed to use the uncollectible rate for the first 6 months of 2024. So that's what's used in the stipulation.
Okay, so the actual rate for the first 6 of 2024.
Correct.
Okay. Okay, thank you. All right, the settlement provision on the customer core expenses. Again, this was one where public staff took issue with the company's initial position, and then you all achieved a settlement on that issue. Can you describe for us the agreed upon call center and billing expenses and explain the recurring nature of these expenses? Just sort of give us some context here.
Yes, so during the implementation phase of the customer core program, the company experienced additional O&M expenses related to call center time. And so the staff took exception to those particular expenses and classified those as ones that were related to implementation and not necessarily expected to continue to occur into the future. However, it's the company's position that a lot of those costs that were, related to kind of focusing on different challenges that the company encountered related to implementation would then also continue into the future and represent what our IT folks classify as hypercare type of costs. And they would then transition into more maintenance type of O&M expenditures into the future. So while we would not be incurring them from an implementation standpoint, we would be incurring them as ongoing O&M associated with dealing with different issues related to implementing a new system. So that was the company's position.
Okay, and so your technical experts that are going to be dealing with dealing with sort of implementing and running the customer core program going forward, anticipate this type of expense, these expenses being incurred
At
sort
least
of
for-
out into the future?
Correct.
Okay. All right. I want to ask you all about the recognition of ARO costs. So this is settlement, it's section 3, paragraph 37 of the settlement provision, if you have that in front of you. But I'm hoping that you can just sort of walk me through what that section of the settlement agreement means.
Yeah, so this is something this was an accounting proposal in our direct case. So as you know, the company has AROs for CCR. We have AROs for nuclear decommissioning, and those represent, I did an estimate, I think based on our balance of total BEPCO AROs at, in 2023, about 94% of our AROs. So what we're talking about here is the other about 6%. But in preparing this case, we identified that there.
And let me interrupt you there. So when you say 94% and 6%, that means 94% of the total, the total amounts encapsulated by the ARO, is that correct?
Yeah, well, when I'm saying 94% and 6%, I'm referring, if you look at Dominion Energy North Carolina's total AROs that we have today, 94% of those are for CCR and nuclear. This provision here pertains to the other 6%.
Okay.
So we refer to it as other ARO.
Okay. So I just want to make sure the record is clear. Are you talking about dollars identified as liabilities? Are you talking about numbers of actual AROs?
I'm referring to, the 6% refers to dollars.
Okay. All right. Thank you.
So
And can you give me a sense of how much that is? What does 6% equate to in terms of dollars? And I recognize I'm asking you to sort of come off the top of your head.
I don't have that figure, but that is something that we could follow up with.
Okay.
If needed. So in preparing the case, identified our practice with AROs, because there was an order, I think in early 2000s, that said all ARO accounting that's recognized under general accepted accounting principles will not be recognized for rate making purposes. So when we are preparing our rate cases, we just eliminate all of those costs. And then we have mechanisms to address nuclear decommissioning, which, that's something that goes back many decades. And then we have a mechanism for CCR, which we've been dealing with. This is our third case now for dealing with CCR. But we identified that other 6%, we were eliminating the ARO and didn't really have any way of putting them back in or any mechanism. So in this case, what we're proposing is let's start recognizing these costs in the same manner as they're recognized for financial reporting, which for financial reporting, if it's a cost related to an asset that's in service today, for example, if we have an underground tank at a power station, the cost of this ARO would be recognized over the life of the power station. That's how it's done for financial reporting, and we felt like that was a good way to do it for rate making as well. So this is basically acknowledging that proposal and that accounting and rate making proposal from our direct case.
Okay, so does this mean that in your next rate case, you will come to the commission with proposed mechanisms to recover these costs, or these costs would otherwise be recovered in your base rates?
So it would just be part of our base
Okay.
cost of service in our next case.
Okay.
Going forward.
Okay, I spoke over you. So in this case, you're just asking the commission to give you that permission to recognize ARO costs as you would otherwise for financial reporting purposes.
And in this case, we have the cost in the 38 million. It's part of that. So it is part of the cost in this case.
Okay, so you are recovering those ARO costs, those costs that were that had been in AROs, you are recovering them in the revenue requirement reflects those costs in this proceeding.
That's correct.
Okay, sorry for my stumble there. Okay.
No problem.
Okay, and it's my understanding that I think it's SIGFUR, perhaps, I think it's actually SIGFUR and CUCA don't agree to that provision of the settlement provision. Can you help me understand why they don't agree?
I do not know why they don't agree with that vision.
Okay. All right, well, I'll check in with the public staff and see if they have an answer to that question. Okay. The one last question for you, and this is where I'm going beyond your testimony, but I recognize that, and I'm asking you to just respond to my questions to the best of your abilities, recognizing that you're not, that you all are the accounting panel. All right. So in this rate case, the company is recovering costs associated with its SLR efforts. And it's my understanding, based on the company's filings in this proceeding, that that the company has achieved SLR with respect to the Surrey Power Station, seeking to achieve SLR with North Anna Power Station. Is that correct?
And since we filed, my understanding is the North Anna extension has also been approved.
Okay. All right. So the company has incurred approximately $985 million in costs associated with those SLR efforts. Does this sound familiar to you?
Yes.
Okay. And I'm assuming that 985 million is a system-wide number.
Yes, that's correct.
Okay. And I won't, do you have any idea what it is on a North Carolina?
It would be
Base.
approximately 4% of that figure.
Okay. Okay, fair enough. What can you tell me about the nature of those investments? Do you understand? I mean, I recognize you're the accounting experts, but what does that almost $1 billion entail?
Yeah, you're right. I have somewhat of an understanding that there's just a number of projects in order to get these license extensions that are required by the NRC. And I think they stretch out for, many years. I know one example is updating the control room from a manual control room to more up-to-date digital control room. But I believe this is something that's covered in witness Mr.
Misikowski's. Yes, and unfortunately he's not here with us, but I just my questions really are, is this more than just simply sort of making filings to the regulator and actually making investments in the plant?
Oh, absolutely. Yes. It's a number of different capital projects at both North Anna and Surrey.
Okay, and I assume that the investments made at North Anna are predicated on or based on experience gained from going through the process at Surrey?
I don't know the answer to that.
Okay. Okay. All right. Let me see if there are questions from any other commissioners. Go ahead, Commissioner Duffley.
So I just had a couple of follow-up questions with respect to the accounting treatment for the other AROs. So will there be a change in the amount being recovered in base rates with this change of accounting?
Yes. So prior to this adjustment, these costs basically were not part of our revenue requirement and were just sort of slipping through the cracks. So this now incorporates those costs into our revenue requirement, starting with this case.
Okay. And then also on page 43 of your direct testimony, you talk about, it's going to change the cost of service study results. And that's what we were just discussing, correct? Or is there something more to that language?
So and maybe this is just technical. So I think I'm referring to just cost of service in general. The cost of service study itself, these costs would have been in there one way or the other because it just reflects the cost per DENC's financial statements. But then part of our regulatory accounting adjustments, we come through and take them out. And what we're saying is we will just no longer have that adjustment to remove them. We'll just sort of leave them in as they're reflected for financial reporting purposes.
Okay, thank you. And then moving to the CCR rider proceeding, are there any costs related to the CCRs that will be recovered outside of the rider?
Any cost in the non-fuel revenue requirement?
Well, just, are there going to be any costs, like, once the rider is established, are there any costs related to CCRs that will not be recovered in the CCR rider?
Well, there are still two layers of regulatory assets related to CCR from.
Right. I'm
from
saying
this case
once we get through the slug of this case and then through the end of 2024 and you start the new rider proceeding. So let's say one rider after. So I understand there's a slug that will come in the defer and recovery
Right.
will be in the next general rate case. But besides that small portion, are there any cost related to CCRs that will not be recovered in the rider?
No, it's our expectation that after June 30th of 2024, all ongoing CCR expenditures would be covered through the rider mechanism.
Okay, thank you. And they'll all be treated, and I know it's in your testimony, I just want to get it in the record. So even if they're quote unquote capital cost, they will be treated as expense and go through the rider.
Right, for rider recovery purposes, we will recover cash expenditures associated with CCR.
Okay, thank you.
And just to clarify too, so all the costs in the rider are asset retirement obligations. They wouldn't be capital like planned service type costs would not be in the rider.
Okay, thank you.
All right, any additional questions? Go ahead, Commissioner Tucker.
Thank you, Madam Chair. Gentlemen, and either one of you can answer this. In looking at the retail operations and the balance sheet on the revenue impact of the settlement adjustments, is that a correct number that your uncollectibles are 168 million? Is that correct?
Mind letting us know what page that's?
Page 1 of 40, docket E-22 sub 694, page 1 of 40.
Is that from our testimony?
Well, it's in my settlement packet. Revenue impact of settlement adjustments for the test year ended December 31, 2023. Take a minute there.
Are you referring to line 14?
Yes, sir, I am.
That's 168,000.
168,000 uncollectibles for all of North Carolina.
So what this represents right here is so in line 1, the 60,863,000, there's embedded an amount of uncollectible expense. I can't remember offhand exactly how much.
Yeah, that's okay.
But this is adjusting that number down. And I could get to that
Well,
number, the cost of service
I've got
study if you'd like.
I've got a question after this.
Okay.
Really, okay, 168,000 on uncollectibles. What do you do? Charge those off?
That's right. Those are
Charge offs.
correct.
Okay, and I see in the documents where in the settlement agreement, Dominion has agreed to look at a customer assistance program and try to, write it in a manner after what Duke's already done. Is that correct?
That's correct.
Okay, did you volunteer that, or was that part of the stipulations of settlement requested by public staff?
That's something that was proposed by public staff. I believe we accepted that in rebuttal, and then it's memorialized in the settlement agreement.
Okay, thank you.
All right, I think that's no additional questions from commissioners, but before I let you go, can you point me to an exhibit in your papers? If I were interested in understanding DomGen, I guess DomGen expenses and DomGen revenues and Dom LSC expenses, are there any exhibits to your papers in this proceeding where I could see that?
Are you referring to,
From the PJM?
it may be in the cost of service study, but we could potentially follow up on that one
Okay,
for you.
I'm assuming that information is in the record and I just want to see it where it is in the record.
I think that's something we could follow up on.
Okay, I'll ask your counsel to provide an email identifying those portions of the record at the appropriate time. Okay, thank you. All right, let me see if there are questions on commissioners' questions. And I will start on this side of the room. All right, Dominion.
Just two,
Okay.
very briefly. Our approach. Chair Mitchell asked you a couple questions about SLR investments and recognizing this was outside of your testimony here. Mr. Miskowski's testimony, she was asking about investments that were not part of the licensing, but you guys just referred to those bottom sentences and.
Yes, so this is on page 8 of Jeff Mishakowski's testimony. Examples of investment projects include turbine control upgrades, fire protection, pipe replacement, thermal shield, flexor replacement, and circulating water pump refurbishments at Surrey Power Station, and plant computer system replacement, reserve station transformer replacement, and reactor coolant pump seal replacements at North Dana Power Station.
Thank you. And then Commissioner Duffley asked some questions about CCR costs. You recall those
Yes.
questions? Is it correct that with the rider, no costs will be left unrecovered or left out? So the company is proposing to recover all its CCR costs, correct?
Yes, that is correct.
Okay. And that's from July 2024 forward?
Yes.
Okay. Nothing further.
All right, with that, gentlemen, you may step down. We appreciate your being here with us today, and you are excused, and council take a motion.
Thank you, Commissioner. Chair Mitchell, at this time, we will move Mr. McLeod and Mr. Lee's direct supplemental, second supplemental, and rebuttal exhibits into evidence.
All right, those exhibits will be admitted into evidence.
Thank you.
All right, while these gentlemen are getting organized and stepping down, we'll go ahead and start with public staff.
Yes, thank you, Chair Mitchell. Would you like me, before the public staff witnesses come up, to move the other testimonies into evidence?
Please do.
Okay. I move that the pre-filed testimony of the following witnesses be copied into the record as if given orally from the stand, and that their exhibits be identified as marked when filed and entered into evidence. First, the testimony of Christopher C. Walters, consisting of 102 pages with 1 appendix and 15 exhibits, filed on August 30th, 2024. Second, the testimony of Patrick Fahey, consisting of 21 pages with one appendix and 6 exhibits, with both public and confidential versions, filed on August 30th, 2024. Third, the testimony of Roxy McCullough, consisting of 22 pages with 5 exhibits, filed on August 30th, 2024. Fourth, the testimony of Jeff Thomas, consisting of 48 pages with 1 appendix and 3 exhibits, both public and confidential versions, filed on August 30th, 2024, and corrected on September 13th, 2024. The fifth, the testimony of Evan Lawrence, consisting of 39 pages with 1 appendix and 3 exhibits, both public and confidential versions, filed on August 30th, 2024, and corrected on October 1st, 2024. Sixth, the testimony of Tommy Williamson, consisting of 45 pages with 1 appendix and 2 exhibits, filed on August 30th, 2024. Seventh, the testimony of Jay Lucas, consisting of 17 pages with 1 appendix and 6 exhibits, both public and confidential versions, filed on August 30th, 2024. Eighth, the testimony of David Williamson, consisting of 39 pages with 1 appendix and 3 exhibits, filed on August 30th, 2024, and corrected on September 16th, 2024. And ninth, this supplemental testimony of David Williamson, consisting of 7 pages with 2 exhibits, filed on September 10th, 2024, and corrected on September 16th, 2024.
Okay, Ms. Keyworth, just confirm for me that Mr. Williams's direct was corrected,
Yes, correct.
or was it only his supplemental that was corrected?
All right, just a moment. We're It was supplemental. Okay. Apologies.
So only his supplemental testimony was corrected.
That's correct. My
Okay.
apologies.
Okay. All right. Having heard no objection to your motion, the testimonies identified by counsel will be copied into the record as if given orally from the stand. Portions of those testimonies are confidential, so we'll ask that you confirm with the court reporter that the confidential portions have been redacted before the transcript is publicly released. The exhibits to those testimonies will be marked for identification as they were when they were pre-filed, and they will be admitted into the record.
Thank you. At this time, the public staff calls Hemant Mehta and Michelle Boswell to the stand.
All right, good afternoon, Mr. Mehta and Ms. Boswell, if you would.
Good afternoon.
Left hand on the Bible, raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Mr. Mehta, can you please state your name, business address, and present position for the record?
My name is Hemant Mehta. My business address is It's 430 North Salisbury Street, Raleigh, North Carolina.
Thank you. And Ms. Boswell, can you please state your name, business address, and present position for the record?
Michelle Boswell. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm Director of Accounting for the Public Staff.
And Mr. Mehta, I might have missed it, but did you state your position for the record?
I did not. I'm a public utilities regulatory analyst with the accounting division of the public staff.
Thank you. Mr. Mehta, Ms. Boswell, on August 30th, 2024, did you prepare and cause to be pre-filed in this docket joint direct testimony consisting of 32 pages, 2 appendices, and 1 exhibit?
We did.
And were corrections to your joint direct testimony filed on September 10th and September 16th, 2024?
Yes, we did.
Do you have any additional corrections to your direct testimony?
No, we don't.
If you were asked the same questions today, would your answers be the same?
Yeah, they will be the same.
And on October 2nd, 2024, did you, along with David Williamson, prepare and cause to be pre-filed in this docket joint settlement testimony consisting of 6 pages and 1 exhibit?
Yes, we did.
Do you have any corrections to your joint settlement testimony?
No, we don't.
If you were asked the same questions today, would your answers be the same?
Yeah, they would be the same.
Thank you. Chair Mitchell, I move that the joint direct testimony of Hemant Mehta and Michelle Boswell, consisting of 32 pages and 2 appendices, be copied into the record as if given orally from the stand, and that their exhibit be identified as marked when filed and entered into evidence. And I also move that the joint settlement testimony of Hemant Mehta, Michelle Boswell, and David Williamson, consisting of 6 pages, be copied into the record as if given orally from the stand, and that their exhibit be identified as marked when filed and entered into evidence.
All right, Ms. Keyworth, before I rule on that motion, let's confirm that was the direct testimony of the witnesses corrected on September 10th and then the second correction on September 16th?
That's correct.
Okay. The direct testimony of the panel will be, that was filed on August 30th, 2024, corrected on September 10th, 2024, and then corrected again on September 16th, 2024, consisting of 32 pages and 2 appendices will be copied into the record as if delivered orally from the stand, and the exhibit to that testimony will be marked for identification, as it were, when pre-filed. The settlement testimony of witnesses Mehta, Boswell, and Williamson, filed in the docket on October 2nd, 2024, consisting of 6 pages, will be copied into the record as if given orally from the stand, and the exhibit to that testimony will be marked for identification, as it were, when pre-filed.
Thank you, Chair Mitchell. These witnesses are available for questions from the commission.
Okay. So you all have been in the hearing room this afternoon while the hearing has been going on. Is that the case?
Yes,
Yes.
ma'am.
Okay. And did you hear my questions to Dominion's witnesses regarding the meeting of the minds of the public staff and the company related to the CCR rider that's set forth in the settlement agreement?
Yes, we did.
Okay. And did, in terms of the Dominion witnesses' testimony as to how the rider will be handled procedurally, do you all have anything to add to the testimony given by the Dominion witnesses today?
Yes, I do have a few corrections. In the initial filing, they have asked for like a $9 million for the ongoing basis. Yeah. In the initial filing, they have asked for like a $9 million for the ongoing expense, but that is for the 12 months. In the first filing, which they do in early January of next year, that I am expecting that won't be like a $9 million because the current expense what we are going to look is only the 6 months number from the July 1st, 2024 to December 31st of 2024. So that won't be like a $9 million. That's what I'm expecting.
Okay. Do I understand your testimony to be the interim rate that they will seek to put into effect will be less than $9 million?
That's correct.
And that rate will reflect costs incurred by the company from July 1, 2024 through December 31, 2024?
Yes.
Okay. And the public staff has not yet audited those costs that the company has incurred. Is that correct?
Yes. The public staff has not audited those costs, and the company has not provided those costs yet.
Okay. And how will, have you all agreed upon how the company will propose those costs for recovery to the commission?
Yes. The company will be filing a rider for the actual amounts incurred. So that's what will be based on, and that's what will be collected in the proceeding year.
Okay. So for the interim,
Even for the interim, they will be for the 6 months they will be collecting, which are they're going to collect from February 1st, would be the actual numbers.
Okay.
And for the interim period, the company and the public staff were foreseeing bringing that to staff conference for commission approval at the time.
Okay. Thank you. You answered my question. And that will happen sometime in January?
Hopefully, yes. Late
Okay.
January, but yes.
Okay, to take effect February 1, 2025.
Correct.
Got it. Okay, so you all will work out among yourselves the audit of those costs and coming to agreement on the rate to be proposed at the staff conference. Okay. And then going forward, after we take care of the interim rate going forward, then Dominion will include with its annual rider filings a proposal for recovery of CCR costs.
That's right. For the daily filing for like with any of the regular riders, from January to September or June, July, and that's when they file in August. And they can update it till September, October, till the hearing.
Okay, and the public staff will engage in discovery and otherwise audit those costs associated with the CCR expenditures in the same way that it audits fuel, et cetera.
Yes, the public staff will engage in the same way what we are doing it for the other riders right now.
Okay. All right. Did you hear the testimony regarding under recovery of costs, likely under recovery of costs until perhaps the end of time, the end of time when CCR costs are no longer sought to be recovered?
Yeah, so we don't expect them to be any over recoveries at this point of time. There might be an under recoveries for some time, and there won't be any over recoveries at this point of time. That's what we're expecting, but there will be under recoveries for some time. And because this is a rolling amount, which if there is any over recoveries or under recoveries, they go into the next year, and that's how they'll be addressed.
Okay. Okay. Anything to add, Ms. Boswell?
We have structured this much like our natural gas annual reviews as far as the rolling component of this. If that's helpful at all for you all as far as a guiding point.
Okay. And you feel comfortable that the company and the public staff are in agreement as to, one, the procedures that you all will employ for this cost recovery mechanism, as well as the sort of, as well as, and it's kind of associated, the public staff's review of these costs and the public staff's ability to bring any concerns it may have to the commission?
Yes, ma'am. We have
Okay.
many discussions with the company to resolve all of those issues.
Okay. Anything, all right, changing subjects on you all. Anything to add to the testimony provided by Dominion's witnesses today regarding Section 3, Paragraph 37 of the settlement agreement, which pertains to the recognition of ARO costs?
No, we don't have any. No,
Okay.
we don't have any.
Okay, and is my understanding correct that prior to this rate case proceeding where the company where the company and the public staff have agreed upon a way in which the company can recover these costs, the company was not recovering the depreciation expense associated with these assets? Is that a correct way of thinking about this and understanding this?
All of the costs associated with these were being removed from the calculation of revenue requirements. So they were not being collected from ratepayers.
Okay. 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 And anything to say about why SIGFR and CUCA do not join in this provision of the settlement agreement?
They did not share that with us, so no.
Okay. Can you, okay. Let's see. Okay, I think that's all I have for you. Let me see if there are questions from other commissioners.
With your permission, I have a couple of things to clarify on. The first thing is on the uncollectibles. As the commissioner asked, like in Exhibit 3B, that's where we have our exhibit has Exhibit 3 where it shows like.
Mr. Maida, if you would, which Exhibit 3?
3-1B. 3-1B.
Exhibit to which testimony?
Exhibit to settlement exhibit, settlement.
Okay. Okay, go ahead.
The company initially asked for like a $2.94 million of uncollectibles. In the settlement, we have agreed upon $2.773 million for the bad uncollectibles, and that's the difference is $167,000.
Okay, thank you. That's helpful.
And I have another one for the customer core expenses. As we have stated in our testimony, the company has implemented a new application after 26 years of replacing the legacy system. And in the first 6 months, the company has mentioned that like they would be expecting some additional costs, and those costs when they have identified it, they were like about $10 million, $10.1 million. And some of those additional costs, which are not related to capital, which are O&M, there were some additional costs which were not related to capital. There were O&M expenses. So those were some of the expenses which we identified them to be non-recurring, because after 6 to 9 months, they are not supposed to be incurring those additional expenses again once the project is go live.
All right, let me see if there are any additional questions for you based on that information you provided. I'm not seeing any. Okay, let me see if there are questions for these witnesses on commission's questions, side of the room. All right. Okay, well, with that, you all, your day has come to an end here. We appreciate your testimony and being here with us today, and you may step down and be excused. And Ms. Keyworth, I'll take a motion from you.
Thank you, Chair Mitchell. The public staff moves that the exhibit attached to the pre-filed joint direct testimony of witnesses Mehta and Boswell be entered into the record and marked for identification as pre-marked, and that the exhibit attached to the pre-filed joint settlement testimony of witnesses Mehta, Boswell, and David Williamson be entered into the record and marked for identification as pre-marked.
Okay, the exhibits to the witnesses' testimony, both the direct testimony of the panel and the settlement testimony of the panel plus witness Williamson will be moved into the record in this proceeding.
Thank you, Chair Mitchell.
Okay, with that, counsel for Nucor.
Thank you, Chair Mitchell. At this time, Nucor would move that the pre-filed confidential direct testimony of James W. Daniel, consisting of 32 pages, be moved into the record as if given orally from the stand.
All right, that motion will be allowed.
And his 5 pre-filed exhibits, one of which, Exhibit 5, is confidential, be marked for identification as they were when pre-filed and entered into the record as well.
All right, that motion will be allowed, and confidential information will be so treated, and please confirm that with the court reporter.
Will do.
All right, counsel for for SIGFUR.
Thank you. At this time, SIGFUR moves that the pre-filed direct testimony of Brian C. Collins on behalf of SIGFUR, consisting of 24 pages and 1 appendix as filed in this docket on August 30th, 2024, be entered into the record as if given orally from the stand. SIGFUR further moves that the pre-filed exhibit of witness Collins labeled Exhibit ECC1 be admitted into evidence at the appropriate time.
All right, Mr. Collins' direct testimony filed in the docket on August 30th, 2024, consisting of 24 pages and 1 appendix will be copied into the record as if delivered orally from the stand, and the one exhibit to that testimony will be marked for identification as it were when pre-filed, and it also will be accepted into the record in this proceeding.
Thank you.
All right, with that, I believe we've come to the end of the proceeding today. We will take proposed orders 30 days from the availability of the transcript or as soon as you'd like to get them in. And let me check in with counsel to see if there's anything else that we need to handle before we go off the record. All right, with that, we will be adjourned. Thank you very much.